Gonzalez. I am one of the co-chairs for the convention, and I'm also one of the co-chairs for this CLE along with Shelley Russell, who's with OTLA. So I wanted to, on behalf of the Washington State Association for Justice, welcome you all to the WSAJ OTLA Combined Convention at Suncadia. And we're hoping that you all have a great time. We have some fantastic CLEs planned for all of you, including this one. So without further ado, we're going to go ahead and get started. So I'm going to ask Shelley to come up and get us going.
Thanks, Lorena. As Lorena said, I am Shelley Russell. I am one of the co-chairs for today's CLE session, which is all about technology and learning how to use those new gadgets that we all have and none of us really know what to do with. But first, thank you all for coming. We hope that you enjoy the program that we've all put together. I know that the convention committee has worked really hard on that, and we've got some great speakers that are going to talk to you this weekend. I'd also like to thank all of our sponsors who've made this convention possible, including this year's platinum sponsors, who are the American Association for Justice, Martinell Alvey PC of Portland, Oregon, Larry Barron and Greg Zuthan of Portland, Oregon, Merrick Mediation Services, Neil and Maria Jackson, the Lawyers Association Trust, Marenko and Associates, and Ringler Associates. I think that's everybody we have for sponsors. Be sure that you check out the sponsor booths in the exhibit hall, and my understanding is you can get passports checked this year. You can also put in your business cards for some great drawing prizes and learn all about the services that they have to offer. Our first presenter is Kelly Anderson. He's from Medford, Oregon, and he's presenting on The Future of Litigation is Here: The Effective Use of iPads and Other Tablets in Your Trial Practice. Kelly is a 1979 graduate of the J. Reuben Clark Law School at Brigham Young University. He has served as a trial attorney since 1979. He received advanced trial training from the National College of Trial Advocacy at Stanford University in 1986 and at Harvard University in 1990. He has served as lead counsel for people injured in Oregon, California, Washington, and Hawaii. He's also handled cases in the Oregon Court of Appeals, the Oregon Supreme Court, the Ninth Circuit Court of Appeals, and the U.S. Court of Federal Claims. He's been inducted into the American Board of Trial Advocates. He's a board member and a Guardian of Civil Justice member of OTLA. And he is our go-to guy when anybody has a question about what to do with their iPad, how to use it at trial, what's the newest and best app out there. And we look to him for all of that advice and so much more, and he's always willing to give it. So please join me in welcoming Kelly Anderson.
Thank you very much. We'll start with what the iPad can do in the courtroom, and then take it apart and show the various moving parts. To show what it will do, I'm taking a case that settled a few months ago in federal court, Clare versus Timber Products, and the issue in the case was who was in charge of the loading operation at a lumber mill. You can see Mr. Clare's truck. He was in the process of putting plastic on the truck when his foot caught in the plastic and he fell to the pavement below, suffering permanently disabling injuries. The presentation that I'm giving is on Keynote, so everything that you are about to see comes from Keynote, which is a trial application. This is a Google image of the lumber yard where Mr. Clare was injured. He was injured in the loading and strapping area, and the defense was in the tarping area, about 150 yards away, there was a fall protection apparatus. And the defense was that all he needed to do was to drive 150 yards to the tarping area, clip into the fall protection apparatus, and he never would have suffered the injuries. So the real issue was who was in charge. It was a case brought under the employer liability law. So this shows the route that Mr. Clare came in his truck as he entered the lumber yard. When he got to the scales, this is what he saw. You can see the scale house there, and just beyond the scale house are 2 signs. And those signs indicate 2 different things. And I won't read through everything because the purpose here isn't to try to win the case, it's to illustrate what the iPad can do. But breaking down those signs, it tells him that he needs to wait at the stop sign. That's a specific command given by the company. He is not to back off the scales. He's to pull forward as directed. He's to proceed around the traffic circle. He then goes on the blue line around the traffic circle to the stop sign. And he's been told that's where he needs to stop, of course. And at the stop sign, he sees this sign and another sign. And both of those signs together, if you break them down, contain an additional 6 commands, specific commands. And I won't go through them each because, again, the purpose is to illustrate what the iPad will do rather than to give a full view of the case. He then drives, as directed, over to the loading and strapping area where he sees these 4 signs hanging inside the loading and strapping area. They're a little difficult to see, so we'll highlight them, and there are the 4 signs. The one on the left gives the 11th command for him to shut off his engine. The next is a little hard to read, so we'll make it more clear, and that's exactly what it says with the exact emphasis, the underline and the italics in the original sign. He then goes to the 3rd sign, which is specific instructions, and again, we won't go through each one. If this were the jury trial, we would carefully go through these instructions. But here it breaks it down what all of those instructions really mean. But the thing that really ruins the lumber company, in my view, the thing that burns them up, is the lift truck operator is in charge of the loading yard. Hard hats are required. And in addition to the 4 signs, there is a memo posted in the shop where the loading occurs, and that memo has specific directions that all plastic must be wrapped on the trailer deck and over the load. And there's that memo again, and this is exactly what he's doing. You can see that he, to the right, in the right photo, he's putting the plastic, it's been under the deck, and then in the right, it's over the deck. Now, the ironic thing is this picture was taken by Timber Products right after he fell, and of course their defense is that he never should have been on top of the load without fall protection. The person you see on top of the load is the safety director of Timber Products on the load without fall protection. He then goes to the tarping area, and again, he sees the sign. And again, he receives the first 4 commands. And then he goes to the, I meant back to the scales. Then he goes to the tarping area. And at the tarping area, you can see the fall protection device. So during all of that travel at the lumber yard, he has received a total of 22 specific commands. Now, all truckers, without exception, who came into the yard did the wrapping of plastic in the loading and strapping area. Not a single trucker could be identified by Timber Products by name as having gone over to the tarping area to wrap the plastic. Why did they do it? And here are the reasons. The forklift drivers were needed to help spread the plastic. The forklift drivers needed to help staple the plastic to the load. The plastic would slip, or the lumber would slip on the plastic if it wasn't stapled down, because he had to travel from where he was loaded up to where you see the stop sign and beyond that to the fall protection apparatus, and that is uphill, and with a truck that's shaking under a load on the plastic, the load would shift. Another thing is that the tarping area could not have handled all of the volume of work if all of the truckers went to the tarping area in order to wrap their loads in plastic. There you see the tarping area, and what is in red is the existing fault protection that existed at the time Mr. Clare was injured. The other is a remedial measure which became admissible in evidence because Timber Products took the position that they weren't in control. And when control is contested, then remedial measures become admissible. So that's what you can do with the iPad. None of that is professionally done. I've never had a computer class. It's, you don't have to have a techie to do this. The iPad has made it simple enough that all of us can do it. Now, the advantages of the iPad over the traditional laptop: the iPad is portable. You can generally go a full day on a battery, whereas with a laptop you'll get 2 or 3 hours generally. It's simple. Absolutely, that's the beauty of the iPad, is its simplicity. It has a fast boot up of 2 or 3 seconds compared to a laptop, which may have a boot up time of 2 or 3 minutes, depending on how long since you last booted up. And it has literally, I've heard quoted 25,000 apps. I have no idea if that's accurate or not. I have about 20, and that's enough for me. These are apps that you cannot get with a laptop, but you can with the iPad. On the other hand, the traditional laptop still has some advantages. It has a remote control that you can hold in your hand and no one even sees it. The iPad does not have that at the present, at least not one that works, in my judgment, very well. Definitely, a laptop is better if you have to put a lot of words in. You can get an external keyboard with the iPad, and we'll talk about that in a minute, but you still have to link up with Bluetooth, and sometimes that can be a little tricky. The laptop has a bigger screen. It's easier to play video because most court reporters will give you a disc to play the video on, and that's easier than converting it to the iPad. And it's definitely easier to print from a laptop. Apple has some proprietary rights on printing. You pretty much have to have an Apple printer to print from an Apple device. Now, a lot of people have asked me the iPad 2 or the iPad 3. What I'm presenting from right now is the iPad 2. It works just fine. The image you see on the screen will be the same with the iPad 2 or the iPad 3. Some advantages of the iPad 2 is it's less expensive. You can pick up an iPad 2 now for about $399. It charges faster, and as I mentioned, the big screen displays the same. The advantage of the iPad 3 is the camera is dramatically better. I have here an iPad 3. If you want to save a lot of money in depositions, all you have to do is take this into the deposition room. You have to give advance notice, at least under Oregon law. I assume the same is true in Washington. You simply set it down. You might have to prop a book up under one side because the camera can either project from the back or from the front. So if you are facing the witness and recording, you can look on the screen and see exactly where the witness is. You can see that it's recording or not recording. If you interview a client and the client has some quirks that you're trying to get rid of, you can simply put the iPad on the table, turn it on, and then have the client watch himself to deal with those quirks. If you're going to use the iPad for recording depositions, and I'm not saying that if you have a multi-million-dollar case that you necessarily should use the iPad for recording depositions, but if you've got a standard run-of-the-mill case, there's no reason that you can't record every deposition. There's no cost involved, but you do need a bigger memory than, you need the largest memory you can get, and we'll talk about that in a moment. But the point is, if you're going to use the iPad for recording depositions, definitely get the iPad 3. The difference in the camera quality is dramatic. The iPad 3 also has 4G capacity. As more telephone companies gear up and dispense their 4G wireless connection, then that's a definite advantage. And dictation is available on the keyboard. There you see the keyboard, and you simply press that button and you can dictate, and it's pretty good. You'll have a few bloopers that'll show up. If you have a case involving a below-the-knee amputation, it may come out as a below-knee amputation. You have those kinds of things. But that's a real nice feature on the iPad 3 is the dictation. Now, memory. You can get iPads with 16 gigabyte, 32, or 64 gigabyte. The one I'm using right now has 16 gigabyte. As I mentioned, it's an iPad 2. I've used about 12, and I've used it heavily for a year. And I'm now deleting files about the same rate that I'm adding them. So for that purpose, presenting evidence in the courtroom, I actually prefer the iPad 2 to the iPad 3. It also works better with an app called TrialPad, which I'll talk about in a few minutes. 32 gigabyte is going to be more expensive. 64 is going to be the most expensive of all. I believe the iPad 3 that I got with 64 gigabyte and the retinal display is about $900. I see no reason really for going with the 32. You're either in or you're out on video depositions. If you're out, you don't need a 32. If you're in, 32 isn't enough. So I'd either go with the 16 or the 64. You'll need a keyboard and a stylus and an HDMI cable. HDMI is high definition multimedia interface, and it is the state of the art for visual acuity. You'll need a dongle. I don't know who came up with that word, but it's what you plug into the iPad, and then on one side of the end of the dongle you can connect to the HDMI, and on the other side you connect to power. And that way you never have to worry about losing power. You also need a VGA adapter, video graphics array, or visual graphic array, is the old style, but it's what most courtrooms have, and it's what is here today. So in my presentation today, I brought my HDMI cable, but because different presenters were going to be presenting with laptops and iPads, to standardize everything, all of the connections are VGA. So I'm using this converter right now. You need a projector, and the projector should be at least 2,500 lumens. That's the light that is projected. If you have less than that, you've got to dim the courtroom way too much. Needs to have a built-in lens shutter so that that's just a window that slides over the shutter so that if you suddenly have to turn off the iPad without the jury seeing something, you can do so. Immediate on and off. The projectors that you could get a few years ago could take 3 or 4 minutes to power on and up to 5 minutes to cool down and power off. The projectors you can get today have the capacity, if you get a good one, to immediately power on and off. Needs to be quiet so it doesn't interrupt the flow of the courtroom. Needs to have the HDMI connection and a strong audio. And this is important because if you're playing, for example, a video deposition, or more likely a clip from a video deposition, if you use VGA, you have to use a separate connection for the audio, and it will go into external speakers directly. But then you've got to lug around external speakers, and the external speakers have cords and they have a power connection. It becomes very clumsy. If you don't have a good internal audio in the projector, then it sounds like your witness is inside a tin can. So the projector I have, I didn't know that I needed a real good audio. And that's the one regret I have, is its poor quality audio. And then it needs to have dual keystone. Keystone is the ability to be in one area and project onto a surface that is not directly in line with what you're doing. For example, this is a layout of the courtroom in Klamath Falls, Oregon. You can see where the council tables are. The walls are excellent to project. They're white. You can project on the wall, or you could put a screen up. But you can't do it from council table without having the image all distorted unless you have the keystroke or the keystone. And you want dual keystone. The older projectors had the ability up and down to adjust the image. The newer projectors can adjust the image side to side as well. You'll need a screen. I like the one on the left better. It's more stable in my view. It's easier to pack around. Useful apps. We're going to talk about a number of them. Definitely, if you have an iPad, download iPhone Secrets. Now, the iPad and the iPhone are virtually identical in their application. There's about 120 secrets. And just take 2 or 3 a day and digest them, and pretty soon you'll be an iPad expert. I'm going to share 3 of the secrets. One is to take a screenshot. You simply take your iPad, and the home key is on the bottom, the on-off key is at the top, and you simply press both together, and you've taken a shot of what's on the screen. That becomes critical because everything that you upload to Keystone, or to Keynote, there we go. Everything you upload to Keynote has to come from your photos. Thank you, Amy. All right. So that's how to take a screenshot. Very useful app. Another is how to do a hard reboot. I've heard people say they've had an iPad for 6 months, they've never done a hard reboot, and they've never had a problem. You will have a problem. I guarantee you will have a problem at some point with the iPad freezing. The best way to prevent that is periodically do a hard reboot. It just cleans the system and you run good. I did a hard reboot before I got here an hour ago. If it crashes, I'm not showing up with a name tag on anywhere. Another important thing is how to quit an application. When you hit the home key, which is at the bottom of the screen, you can change from one application to another, but many people don't realize that the original application is still running in the background. And if you use it for a while without quitting, you could have 20 or 30 applications running in the background, all of which slow down the machine. So just press the home key twice, and you'll have all of the open apps come across the bottom of the screen. You just touch your finger on the minus sign, and that closes the app. Very important to do. To do errands. This is one of the best applications that exist anywhere, and there's a lot of organizer applications. I haven't found anyone that does it any better than this. This is a dashboard view of errands. You can see that you can add folders on the left. The folders on the left are simply where you group your projects. By editing, you can delete folders at will. And on the right, you can add tasks to do. For example, the CLEs case that I showed you about, this is back in February. I still needed to do these things, including jury instructions, a site visit by our expert, a truck driving expert. So it's very easy to add things, and you can press edit, and you can take things away. Dropbox is the gateway between whatever your office computer is, whether it's a Mac or whether it's Windows-based. The way to get information from there to the iPad is Dropbox. There are other service providers that do the same thing. I use Dropbox because I know that it works. And it's the easiest thing. You simply open 2 screens, your file that you have at the office and your Dropbox at the office, and you simply highlight the files that you need to move to Dropbox, and then you just drag them over, drop them in Dropbox, and go do other things. It will upload in however long it takes, depending on the size of the file. Here's a dashboard view of Dropbox. Now we have, continuing in the CLEs case, we have the exhibit And now we want to get it to a way that we can present it in the courtroom, because Dropbox is not the vehicle to present in the courtroom. For one thing, you're connected to the cloud at this point, and if you lose your connection, you've lost your image. And so you just hit the arrow in the right-hand corner, and it gives you various options where you can upload this information from Dropbox. In this case, we're going to upload it to iAnnotate, which is an application we'll talk about in a moment. We could also upload it to TrialPad or any of the other applications. A word about TrialPad: it's the best trial presentation app that I have found, but it does have some quirks. And one of the quirks is if you have more than 10 of these apps that you can open things in, TrialPad drops off your options. And so you have to delete other apps to get TrialPad there. iAnnotate. I use this constantly, and you'll see why. It allows you to mark and search text. So here, if you look, we have 198 imported files that I have or had at this time in iAnnotate. I blocked out the names of clients, but there you can see the imported documents, and you can see the fourth one down is the Clare case. There were 88 documents uploaded in that case. We're going to talk about another case. This is Gremmel's. This is a drunk driver hit a pedestrian in the crosswalk. And in the Gremmel's case, there are 29 files, as you see. And that divides between attorney notes, depositions, and so forth. Let's go to depositions. There are 5 depositions. And there you have it. And the drunk driver is Lester Bostwick. So we're going to open Bostwick's file. And there I've annotated in yellow the things that give me caution, that make me think, okay, the other side could use this against us. In green, I've highlighted the things that are the real go-ahead, the strong parts of our case. I have a general rule: if yellow outnumbers green, you have a problem. On the right is a tab that you can touch, and it gives you all kinds of options. You can see in the right, you can highlight in yellow. Well, actually, the first that you see under the star, there's the wrench, which allows you to add or take away options. The star allows you to search things. The yellow and green boxes with the tags on them allow you to bookmark things. And then green and yellow highlighters. So let's go to the star, for example. And if you go to the lower left of the screen, you can see a search option, magnifying glass. So we'll go up and type alcohol in the search bar, and there are the references to alcohol in the deposition. Now, this isn't all the references. They go quite a bit. And in a drunk driving case, you'd expect that alcohol would be talked about quite a bit. But where the search feature really is helpful is, let's say a witness talks about the car length was he was following 3 lanes behind. And you remember that he said that, but you don't remember exactly where it is. You just type 3 lanes, or just type lanes. Be sure you spell it correctly, and there you've got it. Also, using iAnnotate, you can make notes on the deposition. This is my summary of Mr. Bostwick's deposition. Now, this isn't the whole summary. It continues, and you just scroll down through that summary as you go along. And then when you're done annotating, if you want to send that document to someone, you can either send it as a PDF that has been annotated. That means that the person who receives the document can also annotate it. Yeah, Tom? Yes, if you have the iPad 3, you simply press the dictation mode. If you have the iPad 2, you can get for free an application from Dragon, and you can dictate into that. It works just as well, except that in Dragon, with the iPad 2, you then have to cut and paste the dictation over to the iPad 3. That dictation feature is absolutely wonderful, and this was dictated, by the way. Flattened means that you're going to send it with the annotations and nobody can change those annotations. They've been pressed right into the document. And original means that you're going to send it and you don't want anyone to know what you thought was important or what might hurt you. And so you can mark it up all you want and you can send it to the other side as an absolute crisp, clean copy. And you can upload it just like you can anything else to TrialPad or wherever. PDF Expert is another application that functions very much like iAnnotate. I don't like it as well for this reason. In iAnnotate, when you highlight something, you can see in the notes section that it automatically generates the content of what you annotated. So you can scroll down. You'll only get the first couple of lines, but usually that's enough to locate the thing that you're looking for. With PDF Expert, you're just writing on the screen, and the image really stays on the screen. But PDF Expert has one feature that iAnnotate does not have, and I've not been able to figure out with all the brain power that went into iAnnotate why they didn't solve this problem. And that is, in iAnnotate, if you read 1,000 pages of documents, maybe there's 20 that are really important, and those 20 pages are what you want to make exhibits. With iAnnotate, you got to upload the whole thing, or at least all of those that you've annotated. With PDF Expert, on the other hand, if you've got these exhibits, you can mark, let's say, 2 pages that are critical to you, and then you can simply extract those pages, and now you have the 2 pages. Another good feature of it is you can have a person sign a document. This morning, for example, I had a document from my office that I needed to sign a declaration for another attorney on a matter of attorney fees. I was able to sign it using PDF Expert and then mail it out. Another good feature with PDF Expert is you can put on an exhibit sticker right in the document itself. So it has those nice features. Pages is something that allows you to edit Word documents. You simply have your documents as you see there, and when you've done editing, you can export them either as a Pages document or as a PDF or as a Word document. So it's a good way to, if you're away from the office and you have to edit a document, this is the best way I've found to do it. Now, I might add that I'm not an iPad junkie, that everything has to be done on the iPad. Most of my work is done at the office, but it's wonderful to get on an airplane with the iPad and read something and mark it. You're not lugging these heavy files. You're not using the yellow marker, which has no search capacity. It's just a great device when you're out of the office. Notability is a great tool for making notes. Now, here's the deal. I blocked out the person's name. This was a trucking injury, and these are my deposition notes. As the deposition was taken, I don't always do this. In this particular case, I typed my notes, and I asked the court reporter and the other side for permission to also turn on the audio of the deposition. So I'm not trying to take the work away from the court reporter. If I ordered a transcript, I'm going to get it from the court reporter. But what this allows me to do is type as it is recording. And then, for example, I push the record button. Later, I can go down, and he indicated that he had taken some EMT classes. And let's suppose I'm not sure that he said EMT. Maybe it was nursing classes. Maybe I typed it wrong. I can put my finger on took EMT classes or any of those words, and the audio recording goes right there, and I can listen to what he said at that moment. It's the best way. If you're going to take notes of a deposition, this is the way to do it. You can also handwrite the notes, by the way, using a stylus. Penultimate is a great application. I used it in the early stages of preparing these remarks. You can simply write on it with a stylus. It's like writing on a big legal pad. But the beauty of Penultimate is you may generate 20 pages. And then you can push your finger on any of those pages and you can move it around wherever you want. You can change the order of things. It's a great device if you're preparing an opening statement or a closing argument in a case. You simply write down your random thoughts, write them down large enough. Now, what you're seeing here isn't as big as the page really is. You can read it as long as your writing is fairly large. So what I like to do is put a pretty bold heading on the thoughts on that page, and then it's just like index cards. You can move them around wherever you want them to be. UPad is an application that functions just like a legal pad. You can press the arrow that what you see across the page is something that disappears when you want it to. But when you press the command for that to appear, you can write with your stylus in fairly large letters, and then it shows up, and when you're done, you have something like this. This is the note I kept on David Ball on Damages, Jury Selection, Chapter 3. And I've always got those notes, and I can send them elsewhere if I need to. Adobe is a great application to write on documents. For example, this is an image from Google Earth. Using Adobe, you can hand a witness your stylus and the iPad with the image that you want to be an exhibit, and the witness can write on it. In this case, we have one witness writing with black, and then we have other witnesses identifying where they were. The nice thing about Adobe is, in this case, you have a witness mark where the pedestrian was hit and where the drunk driver was going before he hit the pedestrian and then where he fled after. And then all you have to do is send it to the court reporter and the opposing attorney, and you can do that in the moment of the deposition. So there's no question that you've altered the document or changed it. You just hit send right while you're there. Maps is a great application. It comes with the iPad. It's not anything you have to purchase. You see dropped pin, the little guy to the left of the dropped pin. In most areas where Google Earth has done their photography, if you're on some back road somewhere a long ways from civilization, this won't work. But on major streets and highways, you just press the little guy to the left of the drop pin, and you will get a Earth image. And you can see in the lower right-hand corner, it shows you the direction. What you see in that image, the lighted area, is the direction that you're facing. Google Earth is also another great app. It allows you to simply type in the search bar whatever area you want to see, in this case the World Trade Center in Portland, and you get whatever view you want from whatever height you want. If you get below about 500 feet, it becomes a little grainy, but up to that, it's just as crisp as you need. OmniGraffle. This is a great program. It has a steep learning curve, but it's great for being able to mark things that you can't do with Keynote. Keynote is the iPad equivalent of PowerPoint, but it's not as powerful as PowerPoint. OmniGraffle fills in the gap between what you could do in PowerPoint with a laptop and what you can do in Keynote. You can also create using a flow chart. If you have a case against a corporation and the structure of the corporation is important, you can create any kind of organizational structure that you need. Teleprompter is a nice app that allows you to be just like Obama. You turn it on. Now, in this case, we have Martin Luther King's I Have a Dream speech, but this can be your opening statement. It can be your final argument. You just upload it into the teleprompter, and it won't take a Word document. It has to be a text document. So that means if you've got a Word document, you have to convert it to a text, which is as simple as taking the Word document, putting it into an email, sending it to yourself. Now you have a text message. Now you simply copy and paste it into the teleprompter. And this is what you then see. And this will automatically scroll down at whatever pace you want it to. If you're a fast speaker, you have it scroll a little faster. If you're slow, you have it scroll a little slower. It is an absolutely wonderful app. Fastcase is free. I have Westlaw. Many of you have paid subscriptions. The nice thing about Fastcase is it's free. And you simply log in and you're good to go. TrialPad is the app that I use in the courtroom. As I indicated, it's not perfect. It tends to have a little temper occasionally, but it is great. It's simple to use. We hired a new legal assistant, 21 years old. I gave her the TrialPad and I said, we've got 81 exhibits that we need to upload. I took maybe 2 or 3 minutes to show her how to do it, and an hour later she had it done. And that was the learning curve, 2 or 3 minutes on uploading. A little longer than that on how to present, but 20 minutes and you're an expert in TrialPad. That's the beauty, is its simplicity. At the bottom you can create any new file that you want, or you can duplicate a file. If you want to have one file, you want to save it as a duplicate so that if you do other things with it, you haven't destroyed your original. That's a good backup. You can upload things directly from Dropbox. You just hit that button and Dropbox comes up and you can pick what you want to upload it into TrialPad. You can upload photos, and they will be JPEG photos, which have a higher quality than PDF, although to most of us they're kind of indistinguishable. And then when you're done, you can simply put the file in the trash can and keep your system running fairly easy. In this case, going back to the Clare case, you can see an exhibit. All of these are deposition exhibits. Now, that naming of exhibits isn't going to be very helpful to you in trial. So if you press the Edit button right up above where it says Depo Exhibits, you hit the Edit button and you can rename any exhibit that you want. So for example, I would probably call this exhibit Plastic Rip. That's all I would need to know, and I would give it an exhibit number. And then the beauty of this is if you press Edit again, you can press any of those exhibits and you can change the order at will. So you can freely change the order of exhibits, and I wouldn't put the exhibit number until the very last when you're comfortable that you've got the order right. Now the bar at the top allows you to do many things with an exhibit. The first half circle arrow allows you to rotate an exhibit. If it's in landscape and you need it in portrait, you can rotate it. The second one allows you to enlarge any area of the exhibit. So if you've got a contract and one paragraph is critical, you simply hit that button and put your finger on the iPad and you enlarge to take the whole screen, that particular part of the exhibit. It has the next icon allows you to mark in 4 different colors. The next allows you to write in 4 different colors, so you can actually write words on the exhibit. The one that has the 2 stars on either side of the icon allows you to block out information. So for example, if you have a document that refers to insurance, you can block that out so it just becomes a blank on the document. The star allows you to put your finger on the iPad and it's like having a laser pointer, and the jury can see whatever you're referring to. They see a pointer on the screen. They don't see your finger, of course. The W is a whiteboard. If you need a blank piece of paper, you simply press that, then you press the pen and you can write on it. You can have a witness write on it. And the last icon at the top allows you to export the document. So you've marked your exhibit, now you want to export it. to make it a hard exhibit that will go back with the jury. That allows you to do that. The bottom is also really important. You can turn the output on or off, meaning if it's on, the jury sees what you're looking at. You can have it on and have a blank where the jury sees nothing but a black screen with a very tiny trial pad logo. You can freeze the screen, which allows the jury to still look at Exhibit 1 while you're deciding whether to go to Exhibit 13 or Exhibit 20. They're not seeing you scrolling through the exhibits to see which one you want. And the present is you press that when you're ready for the jury to see what you're seeing. The 2 pages that you see near the bottom of the screen, to the left of undo, you press that and you have 2 different screens that show at the same time. How many minutes? 2 minutes. Evernote is a great app. It allows you to store information. When I go through my mail, when I see something that is really critical, I will have my legal assistant scan it to Evernote, and I'll write the tags that want to go on it. For example, and later you can search those tags and find the information that you want. So it's very easy to do. Books on visual advocacy. I highly recommend Beyond Bullet Points by Cliff Atkinson. It's a difficult read, but it's well worth it. It's just packed with information. Show the Story, which are written by the Bailey brothers, which I believe are members of the Washington State Bar, is excellent. I highly recommend it. And Now What Makes Juries Listen by Sonia Hamlin is a great book. It's kind of spendy, about $200, but it's well worth it. Finally, going to the drunk driver case that I mentioned, bullet points are death, if that's all you have. But if you illustrate it with photos, in this case you have where the drunk did his drinking at the Corner Club and the Pioneer Club, where the pedestrian was hit, just having the image of the 2 taverns gives something to it. He left the tavern at 4:46, or he hit the pedestrian at 4:46. He was in cuffs 5 minutes later. He had a blank stare, searching for the door handle, used the door to balance, upper body sway, strong odor of alcohol, confused, did not reply to questions, bloodshot eyes. The trial pad is the greatest tool that I've found because it's easy to use and it's ubiquitous. So I appreciate the opportunity to present. I'd be happy to answer questions during a break if need be. And if there's time for a question, I don't know. Shelley's the czar on that, so. Yes?
I didn't hear you mention CloudOn, which is a great app in the cloud that allows you to do Word, Excel, PowerPoint. It's free at this point in time.
Okay.
And it'll save, you can kick your save file back to Dropbox, right? That's Dropbox. It's a great way to
Okay.
provide.
All right. The comment was CloudOn allows you to do the same thing as Pages and edit it that way. Yes, this would be the last question.
You know, as a technological dinosaur, I really appreciate your presentation. For me, it was the simplest method of going into the courtroom with a trial notebook in your hand is Trial Touch. DK's here at the convention that developed this because it's for people like me that are really need the simplicity of it, and it's another application I think that would be well worth people's effort to look into.
All right. Thank you all very much.
Thank you, Kelly. I don't know how many of you were out there playing with your iPads or tablets while Kelly was giving his presentation and looking up those various apps, but I saw several of us out here with kind of playing along. That's great. Well, another area that is becoming more and more prominent in each of our practices is discovery of social media. I do employment law, and so we see often requests for our client's entire Facebook account, and if you don't know what's on there, you can be surprised, and the defendants like to use that information against us. So we have asked Oregon's own e-discovery expert, Catherine Heekin, to come speak to us today about what you don't know about your client can hurt their case, e-discovery of social networking sites. Catherine is the founder of the Heekin Law Firm in Portland, Oregon. She did her undergraduate studies at Princeton University, got her JD at the University of Oregon School of Law. She's been a member of the Oregon State Bar since 1994 and the Washington State Bar since 1999. Her practice is a general civil litigation practice with an emphasis on fraud-related claims. She's a member of the National Trial Lawyers Academy Top 100 Trial Lawyers in Oregon in 2010 and 11. She is a certified fraud examiner, a member of the Association of Certified Fraud Examiners, which has been identified as the premier financial sleuthing organization by the Wall Street Journal. She is a former chair of the Oregon State Bar Uniform Civil Jury Instruction Committee, and she provides e-discovery and ESI management consulting services to corporations and lawyers. Please join me in welcoming Catherine Heekin.
Thank you. Nice to be here. Enjoyed the 4-hour drive up. Just got here in time, and that's why you might have seen me over there with my daughter. But it's a great place to be, and thank you for having me. I brought with me Cliff Torn, who's with a company called Tiger Logic, and the reason is this social media has sort of taken on a life of its own, and I think one of the challenges in dealing with electronic information is how to gather it in a way that is visually appealing, and I think Kelly was doing a great job showing how far we've come, but when you're doing the discovery part as opposed to the presentation part, as you probably know from your own practice, the volume of electronic information can be so overwhelming that the ability to review it in a way that's cost effective is a big challenge. And so I met Cliff at a Software Association of Oregon event, and the product that we'll use in our presentation later is not yet tailored to the litigation support market, but it allows us potentially to show you uses that you can make with social media that could help with client selection, client tracking of their social media while you're representing them. Also, if you've got products liability cases, how you might track what the company is saying about its product. And then the third potential use of the application is juror selection. When you've identified who the jurors are, it might not be something you could do in actually selecting them, but once you have them, you can go out and grab what's in the social media sphere and get a better understanding of who it is that you're presenting to. And again, that might be more useful in a longer presentation, a 2 or 3 day, more than a 2 or 3 day trial. But again, this is sort of show you what the cutting edge could be and how we can sort of adapt to the electronic world in ways that haven't happened yet. But before we do that, I have about 20 or 30 minutes. We've got 50 minutes together, so I'm going to do 20 or 30 minutes of where are we right now in terms of case law, in terms of practically how do we do the collection and the preserving of social media. And then we'll do the presentation with Cliff's Postano is what it's called, and then the last 10 minutes or so we can have question and answer period. And for those of you who are Washington lawyers, in the materials that I prepared, there's not a lot of Washington cases. So if we get to the end and you know of Washington cases, whether it's trial court decisions or Court of Appeals decisions, appellate decisions, I should say, then let's know what those are so everybody can benefit. All right, with that said, here's why you need to understand electronic information and how to collect it, and not just emails and Excel, but social media. I'll give you an example. There's a case called In Re B. Carlton Terry Jr. It was a Judicial Commission ethics investigation that resulted after plaintiff and defense counsel were in the chambers of the judge, and defense counsel said something about being on Facebook, and the judge said, "Oh, I am too," and the plaintiff's counsel said, "I don't really know what that is, and I don't really have time for it." And that was sort of the end of the in-chambers conversation. What happened after that is the judge and the defense counsel friended each other. and were communicating during the case. And in addition to that, the judge went out and looked at the social media of the plaintiff. And when he ruled against the plaintiff, he quoted from some of her social media. And what the plaintiff's lawyer had to do, obviously, was move to vacate the order, and then the judge ultimately voluntarily disqualified himself. But the only reason the plaintiff's lawyer even found out about what the judge had done was because the judge disclosed it after he had made his ruling. So, ignorance is no longer bliss. For those of you who say, you started practice before there was even a computer, and maybe the big thing was to have the Selectric where you could use the correction tape on the typewriter. There's another case for those of you who fall into that bracket that you ought to be familiar with. It's called Griffin v. Maryland. And in that case, the judge said, it should now be a matter of professional competence for attorneys to take the time to investigate social networking sites. So we're here, and you need to know. And so I'm here to help you understand what you should be doing. The last caveat I'll give before we launch into some of the slides and the particulars of how to do it is the ethics that surround how you communicate with your client about social media. So I have thought that email was great for plaintiffs' lawyers because businesses and employers say the dumbest things that are so helpful to our cases. I think social media is one of the best things that happen for the defense bar. And so we plaintiffs' lawyers must take the time when we meet with our clients and consider taking their case, do an evaluation of what their social media use is. But when you do that, if they tell you that they've had a minor impact soft tissue injury in an auto accident, and the defense is going to make a big deal about chiropractic visits, and in the old days what they'd do is they'd hire the investigator who would track them and then show at trial, here's the video of them water skiing. Well, they don't have to pay for an investigator to do that anymore. All they have to do is go look at what they've posted as their pictures from the weekend on their social media, and they'll see them water skiing. So before you invest much in the case of that kind of a client, you need to know what is it that they are posting and how does that relate or not to the case. Do they have privacy settings in place? Because there's going to be, as I go through the cases, a distinction between privacy settings and what's in the public space, like on the wall of Facebook. And then what you have to understand is, even if they've already posted things that you think aren't great for the case, just because it's social media doesn't change how we approach it. It's just as in the old days, you wouldn't tell them to go hit the shredder. We know what happened with Arthur Anderson when they did that. You don't want your clients to do that. But if you do tell them, we need to, I haven't hired you yet, so if you want to go home and, kind of clean that up and then, you haven't hired me yet, so if you want to go home and clean that up and then come back, we'll work on that. That's a problem because there's a case called Lester v. Allied Concrete Company. And what happened there was the attorney told his legal assistant to have the client take down a photo while the case was underway that was on Facebook that was contradictory to the position that they'd taken in the case. The verdict in that case was a $10.6 million verdict. The defense became aware of the spoliation of evidence and sought sanctions. And what they sought was to have the verdict thrown out altogether. The judge didn't go that far, but she did assess a $540,000 fine against the lawyer and a $180,000 fine against the client. And the lawyer was then going to be under investigation for ethics violations, candor towards the tribunal, the way in which he oversaw the work of the paralegal. But he was in the sunset years of his career, and he decided this was a good way to go out, and he just resigned from the practice. But those are sort of some recent developments that you should know and take seriously so that you develop greater competence in dealing with social media. So let's move forward in how we do it. So what to ask in your client intake, your screening. In your notice, so you're going to have a notice of preservation, but here are all the places you're going to be asking your client. Do you have a laptop or a iPad? Do you have flash drives? Are you on Google? And let's talk about Google for a minute. Those of you in Oregon, particularly in the Bend area, may know of a case where it's a criminal case, and a lot of times the criminal cases in this arena are helpful because these issues are coming up in motions to suppress, and we're getting more decisions there than we find in the civil side of things. But this is a criminal case. Woman accused a guy of rape, and she had gone home after the incident. She'd met this man online and then went back to his apartment, claimed that she had been sexually assaulted. There was a criminal proceeding. She went home and entered in to Google some searches about rape, and the criminal defense lawyer wanted to get copies of her searches. And the Stored Communications Act, which we'll cover later, limits the way in which somebody can get access to information at an internet service provider. So even if you try and subpoena it, privacy rights are going to prevent the Stored Communications Act is going to prevent the internet service provider from giving that information. But first the criminal defense lawyer tried to get the information that way, unsuccessful. So he went to the court and sought an order requiring the provider to turn it over, and the victim to turn it over. And the judge granted the order, and the prosecutor was slow to file an appeal of that order, a mandamus of that order, and because of it, the ruling held. And what that meant, but the prosecutor said, even though there's this order, Judge, I can't do anything about it because I can't go get that information because I'd have to have a search warrant or probable cause. That's the legal hurdle that we have to get over. And the victim obviously wasn't going to voluntarily do it. But that's sort of the legal issues that came up, and the reason that you want to talk with your client about, what's your Google use, what have your searches been, because even searches now are potentially troubling for your case. And then we've got the smartphones and the cell phones, and nowadays, with the amount of gigabytes that we have on the cell phones, you can literally have what used to be a whole computer's worth of information on your smartphone, and that's a totally separate topic about how you gather that and so forth. But these are the questions you want to ask, and obviously, are you on Facebook, MySpace, Tumblr is like a blog version, all kinds of places like that, LinkedIn, DVD, and so forth. The notice to preserve, so with your client, you're going to need to let them know what they have to preserve, and then you're also going to want to be able to communicate with the internet service provider or the social media company. And this is the kind of information that you would need to include in the notice to preserve. Now, we're going to later in the day have a presentation about the cloud. There was somebody over here that talked about the Cloud On app. We already have questions about when somebody's emailing in their workplace. Is that owned by the company or by the individual? I mean, do they have a privacy right in that? So now we've got social media, and what if you're posting or reviewing your Facebook, your LinkedIn while at work? There is information that will end up cached on the individual computer. Is that discoverable? But all of that leads to the question of who owns it and how can you access it. So let me go, and when you think about who owns it, we're talking about privacy rights. And this is an area that's got a lot of uncertainty around it. And just like in the Google example I gave in the Bend criminal case, privacy rights came in there, Fourth Amendment comes up a lot, not relevant, overly burdensome. Those are the common objections. But how have the different courts around the country resolved those kinds of objections? Well, the best place to start is, here's the list of some of the cases we're going to be going through, but the best place to start is this Kwan case, and probably many of you are familiar with this case, but if not, I'll just quickly summarize it. It involved a police officer who had use of a pager as a part of his work, and it was clear in the police department's policies that the pages were company or department property. So there wasn't an expectation of privacy there. However, when they were experiencing overage charges, they allowed the officers to pay for those overages themselves. And there was another officer who was responsible for collecting the overage expenses from the various officers. And after a while, he got tired of collecting the money, and also the chief became concerned about whether the plan they had just didn't have enough usage such that there might be an emergency or something they would need to respond to, and they couldn't because they capped out on the amount of space that they had for the pagers. So what they did is they decided to investigate the usage, and they went to the telecommunications provider, Arch Wireless, and obtained the pages of this officer within a certain period of time to evaluate how it was being used. And the officer who was doing the review was careful. He looked at the schedule of the officer to confirm that he was only looking at pages that were within the time periods that he was at work. So anything that was outside of work he wasn't looking at, just the things that would fall within his normal workday. Well, even within that narrowed set, he came across sexually explicit communications with his girlfriend and other non-police work communications. And because of that, the police officer was disciplined. And he challenged that discipline, and part of what he contended was this was sort of an unreasonable search of Fourth Amendment rights, privacy rights. And it went all the way up to the Supreme Court of the United States. And this is Justice Kennedy wrote the majority opinion. And what he said is, we're not going to really deal with the technological issues. We're not going to really deal with whether there's a reasonable expectation of privacy. We're just going to assume there is. And part of his justification, if you were to read this long quote, is, well, we back in the day when we were just talking about telephone booths and you walked into one of those, in the Katz case when they were talking about unreasonable searches, they could all relate to that. If you close the door in the telephone booth while you're intending to have privacy over what you're communicating by phone. But they said, well, we're not really understanding this technology nowadays, so we're not going to talk about whether there is or there isn't, and it's moving too fast. So instead, we're just going to assume there is, and we're going to say that that the search that was done was legitimate because it was had a work-related purpose in establishing whether the extra usage was for work, and therefore they needed to up the minutes on the plan. Or whether they should keep it where it was. And so the Supreme Court said it was legitimate because it was a work-related purpose and it was not excessive in scope. But Justice Scalia wrote a dissent, and although normally I'm not a Justice Scalia fan, I wholeheartedly agree with what he said in this particular situation. And what he said is he criticized the majority's opinion because they were delving into why they couldn't opine about whether there was a reasonable expectation of privacy, that it's too hard to understand the technology. And he basically said, this idea of the times they are a-changing is a feeble excuse for disregard of duty. And he said that, where privacy is concerned, we should decide less than we otherwise would, or that we should hedge our bets by concocting case-specific standards is just going to lead to a whole series of problems. And what he talked about is what will happen is we'll have inconsistent approaches driven by how employers set their policies, because we'll be looking at what the different handbooks say to know how we should act in any particular situation, and that doesn't create certainty. And then the next thing that he talked about is we'll have state legislatures will be trying to grapple with this, and mostly what he spoke to is how difficult it is to keep pace with the change of the technology and to know what should be the standard for, in the old days, sort of the curtilage around the house, and you have our expectation of privacy there. Now it's hard to know what is private or not, and that is where we see difficulty in how a judge may decide whether a particular social media is discoverable. So how do you get it? Let's talk about that for just a few minutes. So nowadays, instead of having to get a subpoena, having to subpoena whether it's witnesses or it's the defendant, the other driver in the case, whatever it might be, or even your own client's information, Facebook's come out with a feature where you can download your information. So if you were to go and Google Facebook, download your information, it would lead you to their instructions about how your client can go grab their own information and have it all kind of in one tidy file so that you can evaluate it. Google's doing something similar with Data Liberation Front. I have to tell you that's not as easily understood, but again, if you go to Google and put in Data Liberation Front, you'll learn more about it. Postano is the software that Cliff and I are going to show you in a few minutes, and then the other way is consent forms, which is at the end of the materials, the written materials, I've got a consent form that LinkedIn recognizes, so you would get a consent form from your client or from the defendant through discovery. You would ask for this, and they would have to give a consent form in order for the provider to release the information. So those are some of the ways that you get it. Now, let's just talk for just a few minutes, like 2 or 3 minutes before we do this demo of what's public versus private, keeping in mind what I said about Quan. It depends on what the social media is. The decisions have come down differently if it's Facebook versus tweets. And the case that is best for understanding how a judge might evaluate tweets is called People v. Harris. And in that case, what the judge decided is that information is discoverable because you have no expectation of privacy in it, given Twitter's terms of service, which say that it's public, and that you can't say you have a reasonable expectation of privacy when you accept those terms of service. So again, when you're trying to figure out how do I deal with these issues, terms of service that these different providers like Facebook and Twitter have are useful, can inform how you might shape your motions to compel. Another case is called Romano v. Steele case, and that was publicly available information. That there was publicly available information on the Facebook page of the plaintiff that showed that the plaintiff wasn't impaired by the injury as claimed in the case. And what she had contended in the case, that she was confined to her bed, and the publicly available picture on the Facebook was of her smiling outside the home, and that led the defense to say, well, this is what we can see in her public posts, so we should be able to go behind that, beyond the wall, into those posts that she's made that are behind the privacy settings, and that was a different result than an earlier case called Crispin v. Christian Augur, where the judge there made a distinction between what's on the wall and no expectation of privacy there because you wanted lots of people to read it, versus having your privacy settings trying to sort of have the curtilage of the home concept in place. So those are some different cases. And then there's a final one, Patterson versus Turner Construction Company. Person had physical and psychological injuries. But the judge said there, even the non-public information that had been posted on the social media was discoverable because it was just like a diary. So a lot of times when you're trying to figure out, can I get this information, or is it likely that we're going to have to disclose it, and is it going to be bad for my case, you should be thinking of what is analogous to it in the old world. Like when I talk about just emails or so forth, and files, you guys can think of, sort of in your inbox, and then maybe you have folders. Well, that's just like the old file cabinet, and then folders within your file cabinet. So, here, when we're thinking about social media and people are writing these very revealing comments about themselves and posting pictures about themselves that show whether they've got pain and suffering, or could be used to challenge whether they do, it's going to be potentially discoverable because somebody's going to say it's just like a diary. So that's sort of the quick and dirty on the case law. And there's another case that I've cited in the materials, and I want to do this demo first, and I'll come back to the rest of this if we've got time, but I want to show you how some of this looks in a way that can be grabbed from what's in the public space without a discovery request. But if you want to know how to do the discovery request and how courts have treated them, this is a case and it's in the materials. But for now, let's take a break and have a demo of some software that can be used in the early stages before you're doing discovery requests to figure out what's going on with the corporate defendant, whether I want to take a particular client because of what they're posting on their social media. So just so you know a little bit about the process that Cliff and I use, I'm on Facebook, I'm on LinkedIn, and I have friends who tweet. I'm not a tweeter yet, but maybe I will. And I gave him Facebook handles for some of the people. I thought about whether I should do it with any of my Oregon lawyer friends, and I decided I wouldn't do that because I didn't know what might show up and I didn't want to embarrass anybody. And I also grabbed the Twitter account from a defendant in a case that I currently have, and I'll tell you, we were able to effectively use his Twitter account in that case. It was a fraud case. It's a business dispute between two owners, and we were alleging fraud, and part of it was we were saying he was misusing company funds. We were saying he was misusing company funds, and a way to establish whether the entertainment dollars of the fund were being used for entertaining clients or not was to look at his tweets. For example, he was using money to buy Blazer tickets, and we were able to figure out from his tweets that he was tweeting with his family at the Blazers games, not with clients. And then another thing that we were able to establish is that he used the company credit card to fly to France, and there was a outpost there for this organization, but he wasn't there to visit that outpost, at least based on his tweets. He was there with his family, and his daughter was on a semester abroad, and those tweets were helpful to show that there was at least circumstantial evidence that he was using the company funds in ways different than what he should have been. So, you have to do a cost-benefit analysis as to how deep you're going to go, but this is an example of how you can do it with a product that grabs what's out there in the public space without having to do discovery requests. So let's go to the first example here.
So thank you. Just as a quick thing, we're certainly not the only people in this space, but what we do think that differentiates us from a lot of the other products that people are using, such as a TweetDeck or a Hootsuite, is that we are actually visual in nature. And I note that Kelly, in your presentation, it was all about how a visual communicated much quicker and was much easier to assimilate than just words on a page. So we call ourselves a social media visualizer, and quite simply, what's the benefit of visualizing social media? Well, it's the old adage, picture's worth 1,000 words. You don't have to explain it. Once you see it, you know it, and then if you have a couple captions there, that adds context, and you've got the whole message without having to read 1,000-word treatise. So how does that look in the social media space? Well, on the left-hand side, there's a client of ours, Owens, Illinois. They do a glass, they're promoting glass usage and packaging. And here's a Twitter stream where they're trying to communicate all the beautiful uses of glass and glass packaging and why consumers should want to purchase something that comes in glass versus plastic. And what we are able to do for them is to help them visualize it, basically extract the visuals, put it in with their text, and make it communicate the beauty of glass at a first glance. So roughly that's the benefit of the product. What we do is we basically three things. We pretty much aggregate anything that's out there with an API or an RSS feed. The second thing that we do is what we talked about, visualize it. We'll go behind the links and actually pull forward the photo, the video, or the article that's being referenced in association with that Facebook post or that tweet. So instead of just seeing 140 characters, you'll get the full video or picture or article along with the explaining comment or text. And then we have a number of ways to configure it. You can put it onto an internal website, onto an external facing website, or even some other applications that some of our clients have used. So let's go into some demonstrations. So Catherine asked me, okay, what would really, let's say the first use is you want to get into doing some client research, and one of the cases we talked about was Bear Yasmin. So I'm going to create, this is our dashboard. Basically, I'm going to create a new Pastano, and that's what we call these things. And what you'll see up here is all the content sources that can be located and fed into your dashboard. So in the case of Bear, I happen to do a little research, and I know that they have a Facebook page called Bear, so I'll add that page. And basically what that does is instructs the platform to go out and find the Facebook page that's called Bear and bring in all of the posts that are along with that. Twitter, same thing. They also have a Twitter account that has Bear. I'm going to include their non-picture tweets as well, just so that we can get their full communication, and we'll add that in. We also have the, oops, sorry, a little slow here. So what you'll see now is it starts to pull in. It goes to the Facebook and Twitter APIs and begins pulling in all of the content that is available out there. So this is an aggregation of both Bear's Facebook and Twitter reads. Now, as far as doing research, we do have search capability. I can't demonstrate that in this particular Pastano because it doesn't go live until it's actually embedded into a destination. But basically, you could type in Yasmin or Yaz into the search box, and it would pull out all of Bear's own communications that had that keyword search in there and make it quite easy for you to do the research and to pull out the relevant content for that. So that's basic. Excuse me. That's about as we can add YouTube channels, etc. One interesting thing is the ability to sit on top of Google News alerts. So just as you would for your own Google News alerts, you could type in one that said Bear, Yasmin, Yaz, and basically pull in everything from the time going forward, basically serve as a relevant dashboard to find out what the latest news and alerts, blogs, reviews, etc. were about it. And we offer a number of ways to pull it in, either automatically in real time or through a moderation panel. What that does do is basically, because it's visual, and I'll give you, let's see, hopefully this is no, that's the other one. Here's the back. So what it does is gives you a visual look, and if you think about how much your client or clients will be posting or tweeting, it might be at most 5 to 6 posts a day. So it doesn't take you more than 30 seconds in the morning to actually go through and find and keep track of what your client happens to be posting or tweeting or sharing out in other spaces. So that's actually, let me show you a full-up version. This is a version that we...
Let me interrupt
ahead,
you for
please.
just a second. Going back to the Bear page, so here's how I decided we wanted to do this. I talked with one of the lawyers in Oregon who does a lot of products liability, and I said, what is it that you've got right now that you'd like to know what the company's saying about its product? And so Jeff Bowersock said to me, well, Yaz is a big deal. So this is a way to know what a company is saying about itself, and if you've ever if you've done any electronic discovery and have worked with like Relativity or Clearwell or some review platform like that, it's not nearly as pretty and easy to look at as this is. So if you're doing sort of background research and you're wanting to track what they're saying about themselves, and let's say you had a few corporate officers, maybe their public relations officer, who you could also put into the suite of information that you're tracking, you might catch them with their own words, which can assist you in how you're showing that the product is defective. So I just want to give that background for why did we do this particular example.
Okay, so then a real-life example of how one's being used. This is a dashboard that we've created for a client, 9 West. Their shoe retailer brand. And what they wanted to have was they didn't have an easy way to share their own social media with their own employees. So those of you who've ever worked with retail clients, a lot of times customers will come in with the ad and say, I want to buy this shoe. And the retail sales floor better know that that's the shoe and that they have it out there. These days, when you're tweeting 5 or 6 different products out there, a common occurrence in the retail floor is the person will say, hey, I saw this tweeted there, and the retail sales force has no clue, and it becomes a bad customer experience. Extrapolate that into the example Catherine is giving you. Pretend this is Bear. So you have basically a look at all of their social media and a quick way to basically click through and see the various communication pieces. That is searchable, by the way, on an ongoing chronological basis, and literally 30 seconds to a minute to basically take that in. Then what we also have is the ability to bring in hashtags. And for those of you familiar with Twitter or Instagram, that's a way of tagging a comment pertaining to a particular topic or conversation. So in this case, they've asked us to configure a hashtag search that basically pulls in everything that a user, a consumer, would create with the hashtag there. So you see people taking their own pictures. This one is a young lady who's quite clearly proud of the 9 West hookup that she's created. This is her own picture, and basically it gives the client or the agency or the law firm the ability to quickly see and go into interesting and relevant content. And then the other thing is that we as a service also database this. So unlike on Twitter or Facebook, where if you want to go and pull something out from the past, even 2 years from now, as long as you're a customer of ours, this will be sitting in a database, searchable, ready for you to come out and bring it out.
Okay, so let's talk about how you could use this. Let's say it's your own clients and you want to track what their social media use is, and you've got their handles for Facebook or for Twitter. Then you can be pulling this information into this kind of desktop that's easy to look at. Now, the challenge is if you're trying to do this for the defendant, if you don't have their handles or they have privacy settings, you're not going to be able to pull this information in. So when you're screening with your clients, the one thing you want to make sure is that they've got their privacy settings in place, because otherwise the defendant can go and pull these kinds of pictures and so forth from what's out there in the public space. This just makes it an easier way for you to see what they're posting. So.
Okay. Just one last thing on the hashtag. This is also an easy way for people to keep track of multiple conversations. So one of our clients is the Oregon's Governor's Office for Film and TV. They're in charge of promoting use of Oregon production companies and locations for the film industry. There happen to be 3 major television projects being filmed in Oregon right now. There's Portlandia, which hopefully some of you have seen. Grimm, which has its new season launching actually, I think, today. And then Leverage, which is another very popular starring Timothy Hutton. And so what they do here is basically they've asked us to configure a, oops, okay, we're not cooperating here today. Sorry, my connections sometimes go, yeah. So something's happening. But basically all of the hashtag traffic that viewers will create about Grimm or share articles basically shows up here, and they're able to quickly monitor and don't know what's happened in my settings here. Sorry about that. Quickly monitor what's going on. Another case, and this is a case of the jury selection, you may have a list of speakers or whatnot that you want to keep, jury members that you want to keep track of. I'll show you the one that we created for.
Okay, yeah, so this is the one where I gave him names of handles for different people from Facebook and tweets and so forth. And the content that came back, and this is because it's out there in the public. He just went and grabbed it, and
so
go ahead and show.
This is basically the list of people. It was pretty easy to go on Facebook and Twitter and just figure out what their handles were. So we went there, inputted it in, and basically here is everything that is open to public view. I'll go back to the display mode. So basically here is everything that somebody will put out there. Carla Lundblade, I think.
You may know Rick, that's Rick Lundblade's wife, for those of you who are Oregon lawyers. Go ahead.
Okay, there's that, and then there's, I think this is your friend here, Tunaball.
Yeah, so Tunaball is the tweet account that we use to track what the other business partner was doing with the entertainment money or the company money for his own entertainment and for his own personal travel as opposed to corporate travel. In the middle there, you'll see chiropractic first. So, think about whether experts that you're using are out there tweeting or Facebook posting. That too can come back to haunt you. That whatever Dr. Homa Pierce is putting out about what she believes is potentially going to be material for cross-examination.
So that just gives you an idea of the kind of aggregation and the quick, easy monitoring that you can take on. Things are easier to see if you can see the visual or the article that's attached to it. It's very easy to see the person's comment as well. And so you get a total holistic view in basically a few seconds worth of research.
And then once you have it like that, if you wanted to search for, it's consistently fed by whatever they post, but once it's in the structure we see here, you can then search for particular words, topics, and so forth. So at first it might seem a bit overwhelming because it's nicer to look at, but it might be at first blush harder to find something. But the way you filter is you just put in a search term at the top there, and it'll come back for you. So again, this is just sort of an example of where things are potentially going. I find one of the hardest things about electronic discovery, social media discovery, is how much time and money do I want to spend going after that compared to what results it's going to yield? And even if I go after it, how cumbersome is it going to be? I think that having to get consent forms and do the subpoena and deal with the motions to compel compared to what we might get is the challenge right now. And so I'm always looking for what's a way that it can be more easily gathered and presented so that I can get at what I need faster. And although this product isn't, completely tailored yet to the litigation market, I wanted people to see what the possibilities are. And if you think of ideas about how can we shape this in a way to make it better for us, then I'd love to know how to do that, because I think we all could benefit from having more efficient use of how to deal with this kind of discovery. So,
no, thank you. Just to echo that, Postano is a platform. And for those of you who are tech savvy, we're about to launch an API. So there's a number of, whether you had ideas that you would ask us, can you do this, can you do that? I'm happy to take those questions and answer those. Or for those of you who happen to be involved with very tech savvy developers, we do have an API that you could then configure and output in a way that's useful to you. Just as a last thing before I sign off here, location-based programs are very, very important. I heard Catherine talking about a few where they knew somebody was someplace. Foursquare is one of those platforms that has an API that can be tracked, and there are a number of other location-based. So if you're looking to track movements of a prospective defendant, plaintiff, whatever, there are ways, assuming they haven't completely blocked it out from a privacy perspective, of having them tell you themselves of where they are and when they were there.
Yeah, that's a really great example of use that we might not think of initially. And the Kyron Horman case in Portland was one where the police right away, this was cell phone, not Foursquare, but the same kind of use where they used the cell phone pinging to be able to recreate where the stepmom went. And, if you've got like Kelly's example, the drunk driver example at the end there, and he shows the taverns. Well, Foursquare can potentially yield some of that information too. So that's our sort of visual presentation. I'm going to go back to talking a little bit about sort of the legal parameters of getting at this stuff and how courts look at them. But before I do that, let's take a moment and ask if there are questions or experiences that people want to share, things that you are wondering in your own practice about how to do based on what's been said, or you came here today hoping you would learn. Anybody? Okay, yeah.
Is there a one-stop resource that would list some privacy settings and recommendations that you give your clients and how they can do it without you spending a lot of time teaching them?
That's a good question. I don't know the answer to that. But I will tell you, along those lines, let's skip ahead in the materials as far as... Oh, thanks. The question was, is there a guide to how to do your privacy settings? And the best way to do it is, go to Facebook and read how they describe the way to do it. But as far as an independent publication that says across all social media platforms, how do you do it? I don't know of one off the top of my head.
And they keep changing it, so even if you had one, it changes.
So, but let me skip ahead here a little bit to some references, since you asked a question about references. So if you want to know how these different social media platforms treat subpoena requests as well as internet service providers, again, they have policies that can help you figure out what exactly do I have to do for this particular one. And obviously, Facebook and Google don't want to deal with these anymore, so they're trying to come up with ways for people to be able to grab their own stuff with the download your information and the data liberation front that I mentioned earlier. This is also the link for finding the addresses for internet service providers when you go to subpoena the information. And then there's the consent form at the end there for LinkedIn. But coming back to how you want to be able to ask for this information and what the courts are going to allow, in Oregon they've said non-content information like username, what's a better way of saying, username, address, email, that kind of non-content information is discoverable, but content within the posts is not discoverable. But that's only been in criminal cases, and that could change. So the cases that you would want to look to there to guide you and extrapolate from there into the civil arena are State v. Mangana and State v. Magana and State v. Johnson, and then also State v. Delp. And then there was a more recent case called State v. Balar, where a criminal defendant had taken his computer to a like a Best Buy Free Geek service and dropped it off and said, I don't want you to look in these folders. I just need you to fix the problem this glitch that I'm having with my computer. The technician, however, did look in the folders that he was told not to look in and saw child porn links and pictures and so forth, and alerted the police. And there was a motion to suppress that was denied. And on appeal, the majority opinion was there wasn't a privacy right, but the dissenting opinion was that they thought Article 1, Section 9 of the Constitution should apply. So I think this is an evolving area, so just because you might hear of a decision that doesn't go the way you need it for your case doesn't mean that you shouldn't go ahead and make the argument that you need to make and see if you get a different result. Yeah.
So, not having dealt with this, so what is the price range? Can you give us some sense of what the bidding is going to be for various levels of access and user?
With the product like what we showed you with Cliff? Okay, yeah. Well, Cliff, do you want to answer? I mean, I'll tell you, before he answers it, one thing I considered is, would there be a way for the trialers organizations to develop its own platform that it wants, and then we each could individually license it as we need for particular cases? But that was just my entrepreneurial idea. I haven't shared that with anybody until now, other than Cliff, so Cliff, have at it.
Yeah, I mean, our platform is everything from do-it-yourselfers, so it can be as cheap as, depending on how much power you need, to how many different feeds and how many different displays you need, anywhere from $10 a month to we have one installation going in at $10,000 for a year. So. Yeah, no, but but I mean, it depends on how many bells and whistles and how customized and how many different views you want. But if you're willing to have it all in one aggregated view and you're not looking for hashtags or things like that, then it could be done as little as $10 a month.
And within that range, what's sort of the typical for the kind of audience you're talking to?
$500 to $1,000 a year.
Do the people that you're searching know that you're doing it, and they find out that you've been investigating?
No, there's no way for it to. It's basically a call to the Facebook API. And now, if you are really technically savvy, you could go in there and figure out who's making the calls and what. But it's not an easy task.
Okay, our time's up. Thank you very much.
Thank you, Catherine. All right, it is time now for our 15-minute break, and I want to remind everyone to go into the exhibit hall next door and thank our exhibitors for supporting the convention. Make sure you fill out your exhibitor passport because you have a chance to win an iPad. If everybody could be back by 3:25, we'll get started again.